Hello everyone, welcome back. As you can see, I'm still in San Francisco. We're still at our workshop, but I wanted to talk to you about the Baker Act and how being Baker Acted might affect your future. So, had a call from a family. They had a loved one who was Baker Acted, and the question was, well, how is this going to affect his future? I think he was mid-20s. And I said, look, I don't have a crystal ball. I don't know how this will affect his future. I mean, I simply don't. I can tell you in the past I had the family of a young man call me. He got Baker Acted, and even though these are confidential in nature, the military said, we won't accept you. And they found it, and there was nothing I could do about it because, as I've said in other videos, you can't expunge a Baker Act. Whatever's there is there forever, which is, I think, unfortunate, but there's nothing I can do about that. I wish I could. So I got to thinking about this, right? If you've got a loved one who is currently in a facility, how would this affect your future? And so this is my personal take on it. This is my personal philosophy. If you allow your loved one to sit there for a period of time, and at some point they get released, because as I've said, look, I mean, the max is 6 months under the Baker Act, which can be extended, but you know, think about this as a 6-month sort of ordeal, potentially. I'm not saying your loved one can get stuck for 6 months, but I think a week, 2 weeks, 30 days, 60 days is not unreasonable. So they said, well, how will this affect his future? And here's what I'm thinking. If you allow your loved one to sit there and take no action, and at some point they get out, I think that does not look as good as if you hired a lawyer to get your loved one out, and now you fight the legality of the Baker Act and they get out. Because if an employee, potential employee, says what happened, and you say, well, you know, they held me for a week or 2 weeks or 30 days and I got released, as opposed to, you know, I hired this great lawyer and he got me out because I was held illegally. I think that looks better, because obviously if you can tell a potential employee or somebody else, look, I was held illegally, as opposed to, well, I just sat there and eventually I got out, or worse, I sat there and we didn't fight to get me out, and a judge ordered me to be detained for another 30 days, or whatever it happens to be. I personally think that fighting to get out without a court order being placed against me, without having sat there for a period of time and not taking any action, and basically saying, well, I didn't take any action because, well, obviously if I'm Baker Acted, there's nothing I can do. Or worse yet, I was Baker Acted because, well, I met criteria, right? That's what I think is someone who is potentially looking at you could think. I think the best course of action is to fight. I've always said this. The minute you get Baker Acted, you should be fighting to get out. And even if for some reason you do meet criteria, there's always a way to fight to get you out, to address whatever issues you have. But if you allow a court to enter an order, if you do not fight to get out, if you do not fight the legality of the detention, and it comes up in a background check and somebody asks you about it, then I think that's a problem. As opposed to, hey, I was held illegally, my rights were violated, my statutory and constitutional rights were violated, and I got released. I think that is the best way to go. Beside the fact, if you're being held illegally, why wait? Why take the chance that a judge enters an order? Why take a chance that you get abused? And I've told you before, we've seen a lot of abuse in these facilities because, remember, nobody knows you're there and you can't sue them for any of this stuff. So that's my personal take on how this could affect your future. You should always, always, always fight to get out. Fight to get out. And with that said, I appreciate you tuning in. I'll see you in the next video. Bye-bye.